Before I begin, I must indicate my locus standi to say what I'm going to. I'm a former judge of Punjab and Haryana High Court. After laying down ropes there, I had a tenure as a judicial member of the Central Administrative Tribunal. Thereafter, I was chairman of the Haryana Fee and Admission Committee, and further thereafter, I was president of the Appellate Authority Pollution Control Board, Haryana. Besides being a fourth generation lawyer, the Almighty has been kind enough to validate my obsession with the feeling of justicing, and throughout, I've been blessed with doing what is essentially called the cause of justicing. I must also indicate the need for the presentation. There is a pandemic all over the world. Everything is topsy-turvy. Businesses have stopped. Of course, unlocking process to a great extent has started. And God willing, a vaccine may also be in the market in very near future. At the same time, I must also make it clear that I am speaking for self. I am not speaking for anybody else or anybody else's behalf. These are my feelings which I am sharing with you in a non-sermonizing and non-venomous manner. The pandemic has been a challenge to our formatted legal justice delivery system. For that purpose, we may initially divide the courts into two categories: the constitutional courts and the trial courts. The constitutional courts facet would include the apex court and the high courts, and the trial court facet will include magistrate courts up to the court of sessions. Though the security concerns are common, absolutely common, but the only difference is that in the constitutional courts, the parties do not have to necessarily appear. That is optional, and they can be forbidden also from appearing. Whereas in the trial courts, most of the roster parts would involve the appearance in person, either of the parties or of the witnesses and the learned counsel who would represent the rival parties. Yes, we were taken by surprise. When this pandemic broke out, we were taken by surprise. We indeed had no disaster management infrastructure in place. Nonetheless, the apex court immediately acted and the virtual hearing started. There might have been few hiccups in the initial period, but things are falling into place by and by. I must clear the air insofar as the rumors going around are concerned. The rumors are that the courts are closed, the temples of justice are closed, that justice is not being dispensed and people are languishing in jail, that lawyers are suffering. On point of fact, all these appear to be misgivings in the mind of the general public, which we must clear. The closure of the courts is a very vague allegation. Courts are not closed. Yes, their functioning is restricted. The functioning is restricted by the concern for the welfare of not only the judicial officers or judges, it is also a concern for the welfare and health concerns of the lawyers and the consumers of justice. I must at the same time clarify that the roster of the presentation today is restricted to the functioning of the trial courts. The other part might be dealt with some other time. So, no blames. You cannot say that the courts are closed or courts are not functioning. When you say justice is not being dispensed, simultaneously, along with the item number 1, it has to be categorically denied. Justice is not being denied. The people are being released. Even the apex court has passed directions on the judicial side for the release of quite a few categories of those incarcerated in the jails. All right, no, no blames for that part as well. Then they say the lawyers are suffering. Yes, that cannot be denied, but that's not due to any fault on the part of the personnel in the justice delivery system. Their interest has to be taken care of in this first of the kind pandemic environment. The duty is for the Bar Council of India and the state bar councils to take care of the interest of the lawyers. Then it is for the bar associations to take interest of their enrolled lawyers. Then it is for the state as well. Very recently, the Bombay High Court in a litigation made observations informing the state that they are lawyers and those attached with them like the clerks, etc., etc., they are a part of the justice delivery system. They facilitate the conclusion of the exercise of justicing. That apart, courts have nothing exactly to do for the welfare of lawyers. The situation is indeed alarming, particularly for the first-time lawyers, those lawyers who come from families which were not into legal profession. It is particularly difficult for the lawyers in the infancy years of service, the practice. Yes, there is indeed something which can be done by a facet of the justice delivery system. The national and the state and also district legal service authorities have adequate funds at their disposal. They have certain eligibility conditions on the basis of which they empanel lawyers. It is time they relax those eligibility conditions and empanel lawyers up to 10 years of standing or even 15 years of standing on the panel of the legal service authorities. They would represent the accused in the matter of remands, etc., and they would be paid therefore by the state. No blames in particular upon the personnel at the justice delivery system. At the same time, there are matters which cannot be dealt with by the trial courts and which can be dealt with by the trial courts. The trials, whether on the criminal side or the civil side, cannot be held because those would necessarily involve the appearance of the lawyers for the rival parties, the witnesses, and so on and so forth. What can be done is the criminal appeals can be heard, the civil appeals can be heard, the cases fixed for rebuttal evidence and arguments, defense evidence and argument can be heard. It is a matter of common observation that in view of the fact that the judicial officers have to dole out a particular quantification of disposal per month, they would complete their quota and forward the other cases to the next month. Maybe it's required for the presently for a duration of 6 months at one go. Be that as it may, it's a fact that the rules require that the arguments have to be heard within a particular duration of the conclusion of evidence. And further, arguments have to be heard in criminal cases within a particular duration of the closure of the defense evidence. It is common to find that the party would say that I have to adduce rebuttal evidence or I have to adduce defense evidence. And on the day the matter is actually taken up with the consent of the parties, of course, the rebuttal evidence is either adduced or closed and arguments proceeded with. In the criminal appeals, the defense evidence is either adduced or closed. It is not to suggest that any party can be or is denied right to adduce rebuttal evidence. If an issue on point of rebuttal arises, a party would be entitled to legitimately adduce evidence. Likewise, it is the discretion of the accused to decide whether any defense evidence to be adduced and ancillary parties that an accused may like to enter the witness box as his own witness. For that, he has to file a application on a proper format, and the court would allow that. The rent appeals can be heard. In all these cases, it's only the presiding officer who, by virtue of the virtual mode, can hear the parties and lawyer for the parties and dispose of the cases. Yes, there are some cases of hardship subject to the tackling of health concerns, the cases involving uh, MSCD claims in which a widow or a family lost the bread earner, that can be expedited. The pleas for permission for the sale or purchase of a minor's share or on behalf of a minor can be expedited. There will hardly be any much of evidence to be recorded. That can be done. At the same time, while classifying, enumerating uh, the categories of cases which can be proceeded and which cannot be, I would obviously say that health concerns have to be addressed in the first instance. When I mention the immediate categories, urgent categories, categories requiring emergent disposal, I may seek your indulgence to say that the cases involving the custody of children ought to be expedited as well. In that case, I am reminded of a particular case, Sumedha Nagpal versus Gaurav Nagpal, or the title may be vice versa, in which the child was with one parent. The child stayed with that parent for a period of 14 years, grew up, and then the order which attained finality at the hands of the apex court was that the custody was to be handed over to the other spouse. The child, on point of fact, was directed to go from the custody of the father to the custody of the mother. It is not my intention, and it cannot be my intention to comment upon the merits of this case. But imagine the emotional ordeal of that child who was called upon to change custody. Is not human mind is not a button where you would press and your emotional concept would change. That aspect also has to be taken care of by the judicial courts. I would conclude by saying, please bear with the justice delivery system personnel. Each one of them, I believe, is concerned with the welfare, the health issues touching the judicial officers, the lawyers, and the consumers of justice. By and by, things will improve, God willing, and the regular formatted justice delivery system will operate. Thank you so much.